I wanted to talk a little bit about what the court was talking about a moment ago. For the people that may not have read these laws, this nice lady gave law writing power to this nice gentleman in the executive branch. But what are the rules that he has to follow if he wants to issue an emergency order? Under 2453, which the court struck down on the state counterpart, just that there's an epidemic and it is necessary to protect health, he issues the emergency order. But who gets to decide the emergency? The people? No. The executive branch decides the emergency. So they control the definition of the emergency. 2451, declare that there's an imminent danger that a condition could reasonably cause disease. That's it. Once they make that determination, they can start issuing orders, closing restaurants, having us wear mask mandates, whatever else they want to do. But you see, as the court is well aware, this is the danger James Madison does not want. That branch has the power of enforcement, and that's where the difficulty lies. We want this officer to have a firearm because he must enforce the law, but he doesn't get the pen. He doesn't get to write the law. He gets to enforce the law. And this nice lady gets to write the laws. She has a lot of power, but she doesn't get a firearm. She can't enforce the law. And then the court gets to interpret those laws on the constitutional basis. So 2451 also allows them to prohibit the presence of individuals. Very broadly drafted, no definitions. 2455, any building that could reasonably believe to be the cause of disease based on the condition. Now that's going to be a restaurant, or better yet, a school. If they find that COVID or some other disease or loneliness or anything that's an epidemic, they can close the school under 2455 because the building itself is the cause of the disease. 5201, if the officer reasonably believes that somebody harbors an infection, whether or not it's present. So you just look at somebody, and the other criteria is there an unwillingness to conduct himself in such a manner as to not place others at risk? That sounds a lot like COVID and social distancing. And
It seems to be a lot more clear guideposts than reasonable and necessary, though. Would you agree?
Yes, but it fails the definition of a law, Judge, because it's not a law yet. And the law must be a law when it leaves Lansing. That's it. It can't become a law. And the law writing belongs to the legislature, but by doing this, they're giving the executive branch broad powers to write laws when they feel like it.
Well, it appears you recognize that there can be some sharing between the coordinate branches, so long as the delegation does not violate the anti-delegation or the non-delegation doctrine. You cited the case, the imminent case from the Michigan Supreme Court.
Right.
You cited it and relied upon it in your brief. It says that you can have that coordination, you can have the delegation so long as there's some reasonable exercise of discretion or channeling of the exercise of discretion, right? So the question is, does 33.5201 have more guideposts which channel the exercise of discretion of the director, local health director, the NDHA's director or otherwise, more so than 2253, which I struck down?
I think that 5201 has the word reasonably believes, and that word struck down the Emergency Powers Act. And the court got the other half of that equation by the word necessary. Reasonable and necessary were in that statute, and both those caused the demise of the statute. The court only had necessary, and that was struck down. So this is reasonable. I think reasonable is worse. It's more broad. It's in the mind of the person. And those that support the delegation of law from one branch to another, and I have found less support for that over the years, Judge, having done this for 4 years now, that I'm not the biggest fan of the non-delegation doctrine that I used to be, because it can be manipulated, and I'll come to that on the vesting clauses in a moment. But that is the law under NRA certified. But these also fall for indefiniteness. There's no time restriction here that how long these mandates can stay in place, and that causes the fatality of it. And the same with 5203. if you're determined to be a health threat to others, you get a warning notice, and it can be oral, just a verbal notice, and you're required to cooperate. I don't know what that means, but it's very broad. Then it goes on to say they can require treatment programs and require medical testing. But these laws were well intentioned in 1978, which was a long time ago, but they were never used.
Would you agree that 5203 is more protective to the individual than, for example, 2253? For example, 5203 allows the department to issue a warning notice. It allows the department to say what an individual must do, engage in testing to make sure whether there's a disease and so forth. But then for enforcement, they need to apply to the probate court. And then there's the due process right. That was an opportunity to be heard. Would you say that's more protective or less protective?
It's more, it is, right? You have the right to go to the probate court. And ironically, one of the suits I filed in this county on the school mask mandates, I filed in the probate court. And Judge Cooper looked at it and said, no, I don't have the jurisdiction. We came to this court. Judge Briscoe decided that case. So now I'm concerned about that because I did go to the probate court and I was told we don't have jurisdiction. So now what happened? And that was a written opinion by Judge Cooper. So now we have precedent in this county that really the probate court doesn't have the authority.
Well, that wasn't on this section, right? You didn't file suit under 5203.
Yes,
You did.
I did. And cited that probate section.
All right.
So-
Judge Cooper determined that the probate court did not have jurisdiction to that.
That's correct. Yeah. And so that is the Let Them Breathe versus local health department, and that would have been filed in 2021 in September. So the court should be able to find that, or if you ask me to submit that to your staff, I'll do that. So the court said more of a probate court on wills and trusts and those types of things, and the county argued that he lacked jurisdiction. So he came to this court under the circuit court, and I still believe that the probate court is the proper venue. But I hear
Whether or not it's probate or circuit, though, that the individual citizenry has the ability to address their grievances in court. Does that make 5203 better able to survive a non-delegation challenge?
it's got a better shot at it. I'm concerned about the earlier language in there about that they get a statement that requires the individual to cooperate. A person could just cooperate and not know they have a right to go to probate. About that. And what happens, Judge, if the health department issues an order under, and they cite 2453, 2451, 5201, 5203, and 2455. Now we've got a basket here, which is what happened on the mask mandates in the school cases. They racked up all those statutes, 2453 and 2451 for sure in the danger. So then what happens to the basket? Half are clearly unconstitutional and some are more suspect. But I stand on the premise that they're going to need a lot more guidance if we're going to allow delegation. And what they should be doing is, which is in my complaint, and we just have some limitations on our briefing, is fact finding. If the legislature says to the executive branch, if you find these facts, you can then issue this order. But I want to see court relief in 2453 and 2451, 2455. The elephant in the room is the legislature has the power right now. So if this is what the public wants, then write a law that would require mandates under certain circumstances. But as I think the court just pointed out, 2453 was the most dangerous because you can prohibit the gathering of people for any purpose, just when it's necessary for an epidemic. And if the we were getting cases in which the courts were saying they were moot until T&B. And T&B said, we need to decide these cases. And so did Ottawa. And now the Berkey case out of the U.S. Supreme Court most recently. But the court has led me to an important area, and that is the vesting clauses of the Michigan Constitution, and quite frankly, the U.S. Constitution. Because I have seen courts in federal areas saying, reasonable and necessary is pretty good. That looks pretty good to me, and we think the non-delegation doctrine is malleable and is flexible, and I don't. And I'm concerned that if the team leaves now to the Michigan Supreme Court, what if they say that in certified was wrongly decided, and non-delegation is alive and well, and the health department has these powers? I didn't want the court to think I created vesting because I provided some Supreme Court briefing in which they say vesting resolves the case because law writing power is vested in the legislature, enforcement is vested in the executive, and interpretation is vested in the courts. That's it. The Constitution doesn't talk about delegation anywhere. That's a judge-created rule, no offense, in the early 1800s by the U.S. Supreme Court. And their location is mandatory. There's no way that the executive branch has this power. They cannot share power that was given by the people. I found an interesting quote that said, when there's a pure delegation of legislative power, it's irrelevant whether the standards are adequate. They are not standards related to the exercise of executive or judicial powers. They are plainly and simply standards for further legislative power. And it doesn't help the court. I think the court demonstrated just now the difficulty of the non-delegation doctrine. Well, couldn't this be reasonable? And isn't there a little more authority here? And I think it's now, at the time I did not, but having litigated this for 4 years, including in the Court of Appeals, the intelligible principle may be on the chopping block. And Justice Gorsuch said that in the Gundy decision in the dissent. But think about this.
So I recognize that you're trying to advocate for the change of law. I think you also recognize that I'm bound by certain questions. The legal framework that they laid out for trial courts, it's laid out for me.
Yes.
Right? I'm bound by it. I've got to go look at the scope, I've got to look at the amount of delegation, the duration of delegation. It's all in that opinion that I have to look at. Right?
Yes, but what prohibits the court from, in the alternative, because the court has made many rulings, whether it's in a business case or an easement case, or in the alternative, the court finds this. What do we pick up? That the court finds that the non-delegation doctrine applies or doesn't apply, the vesting clauses should. And there's no prohibition of that. There's no case that's ruled on the vesting clauses. And you've got clear language in the Constitution that vests that power. And there it should stay. And what right does the legislature have to give power to another branch? Where does it say that? In fact, the Article 3, Section 2, the separation of powers says they can't. This is a judge-made rule that's really interfering with what the plain language of the Constitution is. And I bet James Madison put those words in there for a reason. So I don't think that the court, if the court disregarded in-rate certified non-delegation, I think that would create an issue. But the Constitution doesn't have any language about delegation at all, but it has vesting. And that's the reason James Madison made it so difficult to pass a law through the House, through the Senate, to the governor, or to the president, but not so when it's an employee at the health department. And so I think that the court has authority to find in the alternative that the vesting clauses prohibit any delegation whatsoever. A few more areas, Judge, and then I will be wrapping up, of course, being generous. Certainly during COVID and during the Iron Pig cases with Ian Murphy, we've heard a lot about, well, I hope you're happy now because now we have no laws at all here, and when people get sick and die, it's going to be because the Iron Pig pushed this ruling. But none of that's accurate. We still have the Emergency Management Act, which I think the court cited in this decision. The Emergency Management Act is still on the books, and that allows the executive branch to issue emergency orders at the state level and at the local level. Now, some would say, well, wait a minute, doesn't that violate what you just said about delegation? I thought they couldn't have that power. It's not a delegation because it's only good for 28 days. To me, it's a bit like the state police closing the highway. They can't close the highway, but they do because we have an emergency. Everyone respects that, and then it's opened up again. So for 28 days, the legislature has allowed an emergency order to go in place, which is a lot shorter than 280 days that we used to endure. and then it gets back. See, so it's not truly a delegation.
Or is it just a delegation that's limited in scope?
Correct.
I'm saying the same thing.
That's right, yes. It meets, in fact, it meets the criteria of the non-delegation doctrine. It's not even a delegation, because it's 28 days to allow the executive branch to implement something. And then after 28 days, the legislature never loses control of that power. They don't really give law writing power to the executive. So that's there right now. So if we did have a pandemic in 10 minutes, the Board of Commissioners could allow the executive branch, the mayor for the city, for example, and those two different agencies, to issue an emergency order, and the health department. So that law was looked at and then certified and deemed to be a proper constitutional framework. So we are protected if we need an emergency order right now.
So doesn't that reasoning cut directly against your suggestion, though, that this court find that no amount of delegation is allowed under the vesting clause? In other words, in recertified questions directly ruled upon a clear delegation and said because it's limited in scope, it's acceptable and it does not violate the non-delegation clause.
Yeah, I agree. I mean, Ian Murphy will tell you that I don't like the Emergency Management Act only because of what I've read about the abuse of what's going to be the non-delegation doctrine. So I think the best way to look at it, and the court makes an excellent point, it is a contradiction of what I just argued. The vesting clauses don't allow this. And that's how I would do it. The legislature, especially now, is able to get together within hours and pass an emergency law if they needed to. If it was really that serious. And they're going to have to fix the Constitution if they don't like it. But those are the laws that we have. And so if you give an inch, you take a mile, as they say. But I think that the best way to argue the Emergency Management Act is it's not truly a delegation. Because when you give temporary power to somebody, you're not delegating that indefinitely. And all those health laws that we just looked at are forever, whenever they feel like it. And so the true constitutionalists would say that the legislature never lost control of their law writing, and that's what the delegation clause does. It gives it away permanently. That's kind of the test I think that you run into here. So you're right, I'm not a fan of the Emergency Management Act, but these laws were never tested the way they are now. And maybe your court was finding that the EMA is unconstitutional. I have to stay true to the Constitution, and I think it's got some issues, but it's on books, and so is non-delegation. And I think social guesting also beyond there because of the indefiniteness of it. Now, I just have a few closing remarks, and I wanted to conclude where I began with three people: James Madison, Benjamin Franklin, and Thomas Jefferson. Now, the court's aware, and so is counsel, that James Madison had said the accumulation of all powers, legislative, executive, and judiciary, in the same hands, the king, is tyranny. And I think we all experienced that during COVID. Now, Benjamin Franklin is one of the signers of the Declaration of Independence. And people said, I don't mind giving up a little bit of my liberty for knowing that the government's in control. The government's going to take care of the restaurants. They're going to take care of COVID. And so there's security in the idea that if you give up a little bit of your liberty for security, you're going to be okay. But Benjamin Franklin said this, and he was there at the signing of the Declaration of Independence. Those who are willing to forfeit liberty for security will have neither. Now, Thomas Jefferson, the drafter of the Declaration, there's a paragraph in there that I put in my complaint, and I want to summarize that and conclude. And that is this: it is the right of the people, when a long train of abuses and usurpations, which occurred during COVID, results in absolute despotism. Now, despotism in the 1700s meant tyranny. Then he goes on to say this: it is their right. But he says more than that, Your Honor. It is their duty, an obligation of the people to do what? To throw off such government and to provide new guards for their future security. July 4, 1776, the Declaration of Independence. Thank you, Your Honor.
So are you arguing for an overthrow of our judicial system or just an unworking of emergency management?
No, I think that, and I've been asked those questions recently, that if we limit law writing to the legislature, where the people have the most control, with the limited terms, the two houses, and the governor and the president, that we will not have these code issues again. I'm not here arguing that the court strike down the Emergency Management Act. It's not really part of the program. The Supreme Court passed on it, and so there it is. But I think that the court can find that the ENA is not a delegation under the non-delegation doctrine. And it also doesn't divest law writing to the executive branch because they never lose control of it. So I always tell Ian, it's a bit like him giving the keys to the dishwasher to close the restaurant up. He's given up the power of control over his restaurant, but he gets those keys back in the morning. If he doesn't, if he gives them irrevocably, he's lost control of his restaurant. So I don't think it's a true delegation under that term when the Emergency Management Act allows the executive branch to have interim orders because the legislature gets it back. Since they never lose control, it is not a delegation.
Thank you, Counsel.